Burning questions.
Insightful answers.
Listener's choice.
With Clement Manyathela.
So, Listener's Choice is all about you curating the content of the show with us. So you co-curate the content with us, because we've got 5 days of the week where we think about, okay, what would our listeners like us to talk about? But Listener's Choice is a feature that we have used over the last 6 years of this show to try and get you to tell us what you want us to talk about. Because sometimes there's stuff, that's not on our radar. Sometimes we just don't have enough time to discuss everything else under the sun. And some of the things may be important to you. So if you've got a topic that you feel we haven't sufficiently discussed, or a conversation you feel is much needed, or maybe you want to understand something a lot better, you want us to bring in experts, just send me an email, shall you? Will you please on cm@702.co.za, cm@702.co.za, and tell us what you want us to discuss and why, and what are some of the questions you have. And then I promise we'll bring in the relevant people to come and clarify that issue for you. Today, we're talking about the issue of tenants, because one of our listeners asked that we discuss today the issue of tenants' rights and responsibilities in South Africa. And South Africa, of course, continues to grapple with a deepening cost of living crisis. The pressure is mounting on ordinary civilians. You've got millions of people who rent their homes, right? That pressure is being felt most acutely. So from rising rental prices, shrinking household incomes, to ongoing disputes with landlords, there are many tenants out there that are navigating an increasingly fragile and at times uncertain housing landscape. And for some, it's a fear of sudden eviction. And maybe for you, it's an unexplained rental increase, or they've withheld your deposit, or you're being locked out and you feel that it's an unfair lease agreement. Or maybe you don't even fully understand that lease agreement. And the tough thing is that we do have legislation in place that regulates the rental market, right? But the reality is that many tenants are either unaware of their rights or they're unable to enforce them. And it's this gap between what the law says and what happens in practice that often leaves some of you as renters vulnerable to exploitation, particularly in lower income communities and informal rental arrangements. So what exactly are your rights as a tenant in South Africa? And what can you do if you're facing eviction or unfair treatment or financial pressure from your landlord? Are the current laws even doing enough to protect you as a renter in this rapidly changing economic environment? Those are some of the questions that our guest will take us through. If you've got more questions you want to ask, give us a call on 011-883-0702 or send a WhatsApp on 072-702-1702. Ann-Suhet Marx is an attorney and director at VDM Attorneys who's going to guide us through this chat. Thank you so much for making time for us, and good morning.
Good morning, Clement. Thank you for having me. It's always good to have a chat with you guys and inform the members of the public on their rights and responsibilities. So looking forward to the chat.
Yeah, let's start with the basics. What are the most important rights that every single tenant in this country should know? The most basic ones.
The basic right is remember the law will protect both parties and will make provision for the rights and responsibilities of both parties. But some of the most basic rights of a tenant will be that you need to be able to actually rent a property that is in a habitable condition, meaning it needs to be in a condition that is acceptable for you to live in, for you to, use the property for whatever you will require it for. In the written lease agreement, there will be made provision for the rights of the tenant, albeit now if there's communal areas in the property that you can or cannot use, etc. But the most important one will be, and the most basic one, is if you lease a property, it needs to be habitable living conditions. So the property must be safe and it must be maintained. Also, a landlord cannot evict a tenant without a court order. even if the rent is unpaid. So that's also a very basic right because it's a big thing that we're getting. What is the notice period that the landlord must give me? Can they evict me without a court order? And in my view, can they cut off my water and electricity for unpaid rent? I think, Clement, if I need to list the top 3 questions that we're getting is, what if I'm in a property that is not in a habitable living condition? What if they want to try to evict me without a court order? What if they cut off my water and electricity? Or maybe, change my locks because I haven't paid rent. I think those are the 3 main things. And they cannot change your locks. They cannot cut off your water and electricity without a court order. Again, one of the most basic rights in the court of law here currently.
Okay. And in your experience, where do tenants most often get taken advantage of?
In my view, I think it is not really a problem regarding of the living conditions. I think it's landlords not following the proper eviction process. Let's say, for example, you have an issue where the rent is currently unpaid. I think landlords, what we see is they're not giving adequate notice. The Alienation of Land Act, the Prevention of Illegal Evictions Act, all my provision for a 30-day notice period that your landlord must give you. They're not allowed to give you a 7-day or a 10-day period to vacate the property. They must give you a calendar month's notice. So I can see some of those rumblings. And then I must be honest with you, some of the other rumblings that we see, and one of the biggest issues is with deposits, either not being returned or unfair deductions being made without any proper justification. We also see, the lease agreement stating which responsibilities are for the landlord, which are for the tenant. And then by the time the deposit needs to be returned, suddenly you have these illegal or unlawful deductions made for maintenance that the landlord is, alleging the tenant needs to be held responsible. So I think the 2 main problems, unlawful processes in evictions, not following the correct process, and definitely people not getting their deposits back, unfair deductions, or, even if the deposit was maybe not even deposited into an interest-bearing account, which it must be. And sometimes tenants are coming to me saying, well, I received exactly the deposit I paid, and I rented there for 5-6 years, and no interest grew on that deposit as well.
Oh, that's so... I didn't even know that part.
Yes, you must. The Rental Housing Tribunal and the Rental Housing Act makes specific provision that a landlord must invest the deposit in an interest-bearing account, and you must get your interest back on that as well.
No, perfect. Thank you so much for actually explaining what landlords legally are required to do with that tenant's deposit. What about the issue of increasing rent? Because with the rising cost of living, there are many tenants that are really struggling. And are there any limits then to how much landlords can increase rent? And what recourse do tenants have if they feel the rental increase is unfair?
So the basic thing what we need to remember is a lease agreement. That's what guides you on. If I'm renting a property for, let's say hypothetically, a year, that is the lease agreement that guides you on what the rent will be for that year. You as the landlord cannot unilaterally increase your rent if not both parties have agreed upon it and if the change isn't made in writing. Now, in South African law, there isn't a fixed legal cap on how much rent a landlord can increase. But I'm now meaning, let's say, for example, the lease agreement has come to an end, the tenant wants to renew the lease, and now the landlord wants to increase the lease again. But if there's an increase, it needs to be reasonable and agreed to by both parties, and it needs to be in writing. Most lease agreements will specify when and how increases can happen. It's often annually, and sometimes it's linked to a percentage. That's, I think, the most common cases currently. But if the lease is silent, any increase discussed between the landlord and the tenant still needs to be fair, and it cannot exploit the tenant as well. I'm 100% aware of, increasing costs and inflation and all of that. So I'm 100% aware that the landlords would also like and also need sometimes to increase the rent to also, either get to their bond and mortgage repayments, etc. But at the end of the day, as long as that lease is in place for that year, the landlord cannot unilaterally increase it during that time. Only once the lease lapses, both parties can have the discussion. It needs to be agreed, and it needs to be in writing, or the lease agreement will have either a specific percentage or some indication when the lease will go up. And unfortunately, the tenant obviously agrees to any lease or any rental increases beforehand when signing that lease agreement as well. If the tenant feels that the increase is excessive, they can approach the Rental Housing Tribunal in their province to also assess whether it is reasonable or not.
Okay. It's 18 minutes after 11 o'clock. What questions do you have for Ann-Suhet Marx? She is an attorney and director at VDM Attorneys, helping us understand what your rights are as a tenant, but also responsibilities as well. So if you've got your own questions, or maybe there's an issue you're facing, you're trying to figure out, how do I deal with this? Call us or send us a WhatsApp voice note. I'll start with your calls and WhatsApps after the break.
Burning questions.
Insightful answers
Listener's choice.
with Clement Manyathela.
21 minutes after 11 o'clock. Ann-Suhet Marx is an attorney and director at VDM Attorneys, guiding us through this conversation about tenants' rights and responsibilities in South Africa. I want to give you an opportunity to also ask your own burning questions. Let's start with WhatsApp voice notes on 0727021702.
Hi, Clement. I hear the fact that tenants have got rights, but they also forget that even us landlords have got rights. I've got a tenant who doesn't want to pay rent, and they are busy saying that they've got rights. What? I can't kick them out. They've got rights, and the lease agreement is expiring month end, so they're taking advantage of that. They don't want to pay me. You understand? So I mean, what should I do as a landlord? Should I suffer now because they've got rights? I feel like it's unfair.
Oh, and of course, as a landlord, you've got rights yourself. And maybe this is an opportunity for us to, on the flip side, speak about the responsibilities that tenants also need to uphold.
Yes, Clement, definitely. Like we mentioned when we started the discussion, the law makes provision for the rights and responsibilities for both tenants and landlords. This is not a free-for-all where just because you have certain rights as a tenant, you can remain in a property, without paying rent. The landlord does have certain legal recourses as well, because rights apply to both tenants and landlords. So a tenant does not have the right to stay in a property and simply not pay rent. Paying rent is the core of the entire obligation under the lease agreement. If a tenant does not pay rent, the landlord will be entitled to take action, but like I've mentioned, as long as it's done through the proper legal process. That means you can't lock them out or cut off any utilities or services, but you can cancel the lease for their breach of the contract. You give them the correct 30 days required notice, depending on, if we're dealing with a commercial eviction, residential eviction, etc., because those timelines can change and can vary. And then you approach the court for an eviction order. You can also claim damages for the unpaid rent. So you can seek the arrear rental as well. Tenants have rights, but they have also responsibilities. The key takeaway is always the law protects fairness. Do not abuse it, and do not think that it falls to the benefit of only one side. Your tenant still needs to pay, but if you as the landlord take the proper procedure, then the legal recourse will be there available for you, and that is where your rights are secured as well.
Okay, got that. And then there's there's a question here on the WhatsApp line, a text that says, "Hi Clement, please can you ask that guest if an estate agent may charge the tenant an administration fee to renew a lease annually?"
All right, so to renew a lease annually, what you're looking at is now we're moving into the Property Practitioners Regulatory Authority, meaning the PPRA, and their code of conduct, their rules and their regulations, as well as their legislation. In South African law, an estate agent cannot just charge an administration or renewal fee to a tenant unless the fee was clearly agreed upon upfront in the lease agreement. But the general principle will be that tenants should not be, especially should not be hit with an unexpected or reoccurring charges that they didn't agree to. Even if such a clause in the lease agreement will exist, it still needs to be reasonable and it cannot be excessive. So, for example, if a tenant signs a lease that says there's a renewal fee each year, that is enforceable. But if it just suddenly appears and it was never agreed upon beforehand, that can may be deemed as unlawful and unfair. So the giveaway is, if there's no agreement, there cannot be a fee charge. And even if there's a fee charge, it still needs to be reasonable.
Yeah, and another one says, Clement, please ask the expert there why municipalities do not get court orders to terminate water or electricity when there are outstanding rates. If landlords can't terminate services to tenants with outstanding rentals and yet municipalities terminate services, that will cause houses to be neglected or abandoned as the landlord won't afford to pay. So the question there is around why municipalities do not get involved and get court orders to terminate water or electricity when there are outstanding rates.
This is a very real concern, Clement, that we're dealing with, but there is a very important distinction that must be made here. Municipalities and landlords are not in the same legal position. A municipality provides the services in terms of its statutory powers, and under certain conditions, it may be lawful. They can lawfully limit or disconnect services for non-payment of municipal accounts. However, a landlord that's a private contractual relationship with the tenant, and the landlord, if they cut off electricity or water or utilities, that can be deemed as the landlord taking the law into his or her own hands. This is also amounting to an illegal eviction tactic, which is also unlawful. That being said, landlords, again, are not without remedies. If you don't pay your utilities or you don't pay your rent, again, landlord can cancel the lease, claim the arrears, and approach the court for eviction. But what we need to understand is this listener that has raised the question has maybe, seen instances where the municipalities do not take court orders or do not actually approach the courts. We have a different view. We have seen the instances where the municipality actually does disconnect the service or lawfully limits it due to non-payment, where they actually do approach the court. So it's not a set case of the municipalities are not taking action, and it's also not a case that the municipality will definitely take action. We have seen in certain regions, for example, where municipalities only intervene once accounts are 100,000 rand and up in arrears. So it is a little bit of a threshold to say they're not going to just disconnect for 10,000 rand or 5,000 rand that's outstanding. But the moment you're looking at 100,000 rand, 200,000 rand, and those damages are just reoccurring, then it is definitely something where we have seen the municipalities do take action.
All right, here's the last voice note.
Clemens, I personally believe that the tenants have too much rights. They are taking advantage of the system. They know there's delays in courts, and for you to evict a tenant as a landlord for non-payment, it takes absolutely long, and the tenant doesn't have to pay you. What happens to the bond? What happens to other expenses, lights, water, rates that you as a tenant have to pay? Sorry, you as a landlord have to pay. What happens to all of those things? This law giving these tenants these rights did not take that into consideration. The courts, unfortunately, there's delays there, and I know it's not the fault of the tenant for whatever reason, but the impact is massive to the landlord. The impact is massive. It's unfair. It's absolutely unfair.
And I'm getting a lot of those kind of messages, and from some people who are saying, but also tenants don't sometimes are responsible and remember their responsibilities, and they always take advantage of the legal system which favors them, and it ends up being too costly on the landlord.
Yes, Clement. We have a very, very, very strong eviction base within VDM Incorporated. We have extremely competent and experienced eviction lawyers, which I must in all honesty say that when we see how, his name is Jason Berkovich and his team, when we see how Jason runs his evictions, He runs it so efficiently and so effectively that yes, it can still be a costly process. Yes, it can be a time-consuming process. And I 1000% understand the frustration of this listener when he says, what happens to the mortgage bond? Because the moment you're not getting rent, you need to pay that mortgage bond out of your own pocket, so meaning that you are at a loss. But it's very, very important to understand again that non-payment is a breach of the lease agreement, and the landlords are entitled to act. However, you need to act within the parameters of the law so that you are not caught up in an unlawful eviction. You're going to follow the parameters and the principles of the Prevention of the Illegal Eviction Act, which is also the PI Act. And I can tell you that if I see how efficiently Jason is running it, I do understand it can take time. I do understand legal fees are involved. I understand the landlord is losing the funds, etc. But your papers need to be in order. You need to have a very, very proactive lawyer. And this has been what I have, because we've shared a couple of videos on this subject as well, where we've assisted many landlords on this, where people have asked the same question, where I've said, make sure you have an experienced or proactive lawyer. You cannot have an attorney who's not specialized in evictions and property law dealing with your eviction, because they don't know where the pitfalls are. If they're not experienced, they don't know where the tenants usually try to take, some of the shortcuts and try to delay and, try to win some time. So you must, a lot will stand and fall with your attorney. But there are remedies for the landlords. It just needs to be done correctly.
Got you. Ann-Suhet Marx, you've been great. Thank you so much for making time for us. She's an attorney and director at VDM Attorneys.